We are here for directions hearing in the matter of CFI-029-2019 before the Registrar Nour Hineidi. The claimant is represented by Banks Legal Consultancy. Lead counsel is Roger Bowden. The defendant is represented by Hadif and Partners. Lead counsel is Adrian Chadwick.
Thank you very much. So I've taken some time to read through the agenda that was prepared by the claimant. I did send a direction to the parties yesterday, which I believe the registry circulated, to outline that the only issue for determination today is whether the claimant is entitled to costs on account or to be paid into court at, say, 50% or less before an application for a detailed assessment is filed. Once we look at that, I want to hear submissions on quantum if I am swayed to make such an order. I have seen Hadif and Partners order that was circulated and was uploaded onto the e-registry in respect of directions. There will be a CMC, and that CMC will be listed before me. It won't be today, though. It will be at a later date when the parties have had the opportunity to discuss case management protocols as you would prior to a case management conference. So we'll put that on the back burner for the moment, and we'll just focus on the issue at hand. Mr. Bowden, I'll let you start. Now, just some preliminary thoughts from my end so that you can tailor your submissions accordingly. I've had some time to read through Justice Chadwick's order in a Khurafi case, which was made in 2017. I think it was, the decision was issued on the 16th of January 2017, and it was Khurafi versus Bank Saracen. I believe that your previous firm was retained to act for Mr. Khurafi at the time. And he made some comments in that particular decision. And the comments are relevant to this extent. Now, I know that the cost order at hand is in respect of the preliminary issues. There was another cost order that was made that is subject almost of an appeal. The appeal has not yet been filed. So basically where we are in the grand scheme of things when it comes to costs is that the position at the moment is not really very clear. And the comments that Justice Chadwick made is that where it's very clear, essentially, that an order will be made in favour of one side, then that side should not be kept away from the costs that they're entitled to. So they should, I guess the wording was, a party who's obtained the benefit of an order for costs in his favour should not be kept out of his money longer than is necessary. But it's very important to take into account considerations like set-off and who the net payee is, and uses these words, who will ultimately be the paying party. I know that the Court of Appeal decision was issued yesterday. There's still a number of decisions to be made. There's still the substantive issue at hand, which is to be determined. So at the end of the day, we don't really know where this case is heading, as far as I'm concerned. So some submissions from both parties, from the claimant and the defendant, would be quite helpful for the purposes of today's hearing. So I'll let you start off, Mr. Bowden, and then I'll let Mr. Chadwick raise his submissions in response. I should note for the record that I did have a telephone conversation. It was a private conversation on the request of Mr. Khalifa some few weeks ago. And the purpose of that conversation was to discuss with Khalifa that the court was not in a position to defer payment of court filing fees. And that was, the conversation was a lengthy one. It went on for about half an hour to 45 minutes, and I discussed with Mr. Khalifa, as I said, that there have been a number of fees which have accrued, they've been incurred, and the court could not provide further deferrals until those fees were paid off. and the matter was no longer a matter that sat with me. As a registrar, the parties might be aware that I've got judicial powers, being the purpose of the hearing today, but at the same time I've got administrative duties to the court, which is to essentially govern the court finances, processes, strategies, etc. And in my capacity as a registrar, I could not waive any further fees. The matter had to be escalated essentially to the government, because we were under a very, very strict instruction to not allow any further fee deferrals until outstanding fees had been paid by the party who was seeking the deferral. So for the record, I just wanted to mention that. And Mr. Bowden, over to you. Thank you.
Can you hear me?
I can, thank you very much.
Thank you. Thank you. Sorry, I was just... Right. If it's appropriate, I would like to simply address the memorandum that we filed yesterday, and speak to it briefly, and also refer to the three cases which are referred to therein, if that's an acceptable way to start. So just going to our agenda, the first issue, issue A, is the payment of interim costs for the first instance hearing. And I appreciate that the main issue is whether they're paid at 50%, and I'll come to that in a moment, or half of that being 25%. And then the subsidiary issues are the payment of the fees for the detailed assessment, the costs appeal, the CMC, the letter to the Chief Justice, if that's still in play, and of course the payment of the fee for this directions conference. And we, for the record, are happy that the direction is either that they're paid directly by the defendant, or that they can be paid by Banks Legal Consultancy FZE by an unsuitable undertaking. We're happy to provide either. In relation to the memorandum, I think paragraphs 1 to 6 are now obsolete, and sorry, 1 to 5. And paragraph 6, just dealing with one of the matters that you raised earlier, Madam Registrar, and that is the issue of payment into court. Our submission on that is that now that the Court of Appeal has given its judgment in relation to costs yesterday, and the order, sorry, I haven't got it immediately in front of me, but the order seemed to be that they confirmed did not disturb the judgment in the court below in relation to costs. Our position is that there's now no need for any further payment into court, and that the costs in the court and the CFI can be resolved in the normal way. And that would be by way of payment of 50% or 25%. Now I'm at paragraph 7. And this actually deals with another point that you came up with, and dovetailing into what Justice Chadwick said in the January 2017 costs award which he made in Karafi. And it has been observed that costs are the lifeblood of civil litigation. And as Justice Chadwick said, we should not be kept out of our money for any longer than is necessary. And I'll come back to that in relation to one of the cases in a minute as well. And the significant problem here for the defendant, for the claimant, my apologies, is that unless he obtains an award of costs, he can't pay the very significant fees which are required of him, and I've listed them above. That is his lifeblood in terms of this litigation, and he will be in a very difficult position moving forward if he does not get those costs. The next point of paragraph 8 is that we accept for the purposes of this hearing, that we're at a maximum of 50%. So the order of His Excellency Justice Mahari on costs set it at 50%. We're bound by that, and we don't seek to go above that. And the issue is either whether we get paid that, or half of that, or indeed any other order that may follow. So that's the second sentence of paragraph 8, and you've already discussed that we have filed an appeal in relation to that, but we don't want to discuss that further here. In paragraph 9, we do have a conceptual difficulty with the situation here. The ruling is currently from Justice Mahari that the cost should be payable at 50% standard. Now, the way I read the rule certainly is that was an immediate assessment of costs. It wasn't immediately given, but there's no problem in having that award provided at a later date. And the subsequent decision by the registrar that the 50% sum be subject to detailed assessment. So we've already got in my submission an award of immediate costs, or there's been an immediate assessment, and now we are moving into a situation whereby there is now to be a detailed assessment. And when we look at Rule 3828, that seems to be couched in the alternative, where the court orders a party to pay costs to another party. It may either make an immediate assessment of the costs or order a detailed assessment of the costs. And our position is that we've got a bit of both here, and that the preferable course of action at this point in time would be to say there's been an immediate assessment, and that is for the payment of 50% of those costs, and that therefore the order ought to be for the full 50%. Alternatively, if it's 25%, just below here I've set out the figures.
Sorry to interrupt, Mr.
Yes,
Bowden.
please.
Could you just remind me of the date of the order made by His Excellency Justice Mahari?
It was right at the end of September. I can find it for you in one moment.
Thank you very much.
It looks like it was the 21st of September.
Thank you.
No, sorry, that's the stay.
It was the 27th of August it was issued.
Thanks.
Thank you very much. As I was. Now, I was at paragraph 10, I believe. The next point is moving on from that, or indeed we now come to the the order of PD 5 bar. It should be 2014, not 4014. Sorry about that. In paragraph 10, where the court has ordered a party to pay costs subject to detailed assessment, unless agreed, it will order 50% of the amount claimed in the statement of costs to be paid on account before the costs are assessed, unless the court sees fit to order otherwise. Now, if we have had, if you like, an immediate assessment of 50%, and now we're to have a detailed assessment of that, I accept that the 50% order under this clause should be 50% of 50%, i.e. 25% of the total. And I've just set those out in the now I think very well known graph or table, which is set out immediately below that. So the 50% sum would be 223,000, and the 25% sum would be 111,000, all in AED. Just on 11, there would appear to be no reason not to order the payment of the amount of 25% of the amount sought in costs, which took place in March in respect of the award made in April, where the costs were claimed on 23 April in respect of, and this is the important part, the defendant has never nominated a sum which it believes is payable in opposition, and really it's failed with respect to nail its colours to the mast on this, and time has really, in my respectful submission, run out, and an order of one or the other, and obviously we're pushing for the higher figure, should be made. Now, just moving on from that, in number 12, I had attached the decisions of Ashman and Thomas, first of all, followed by Hull and East Yorkshire and Musawi. If we could turn, and hopefully you have it before you, Madam Registrar, the attachment 1 to the agenda that we sent through yesterday.
Just bear with me, please, Mr. Bowden, while I pull it up. Thank you, Mr. Bowden.
Yes, and I apologise. I should have inserted page numbers into that. I didn't realise I ended up being in a bit of a rush, but I have bookmarked it on the left-hand side if that's helpful to you.
Yes, thank you.
And really, we're at this point, if we go, and this is probably not bookmarked on your version, but if we go to paragraph 2 of this decision from Master Matthews, that sets out the CPR rule 44.2. Now, there is a slight difference between the CPR rule and the Rule 5/2, PD 5/2014, which we've been looking at. And the difference is this: where a court orders a party to pay costs subject to detailed assessment, it will order that party, and here's the difference, to pay a reasonable sum on account. And so the difference in the DIFC version of this rule appears to be that the DIFC have taken 50% as being the reasonable sum, and thereby dispensing with the need for any detailed inquiry into what's reasonable. It's taken a rule of thumb approach, and of course each one has got the same codicil unless there's good reason not to do so. Moving on to, I had previously highlighted paragraph 7 as being of particular importance, but I think that's sorted. I apologise. I would wish to just draw brief attention to paragraph 6 in relation to the issue of detailed assessment as to whether this court is bound, or the registrar is bound by her previous decision to order detailed assessment. And I think the rule is here at paragraph 6, sentence 2 of paragraph 6, if we look at that, but the court retains power to alter its judgment or order at any time until it is entered and perfected by sealing, and references to well-known cases of Burrell and Riel. And the point being, Madam Registrar, that if you now determine that in light of what the Court of Appeal have ordered, that the 50% was an immediate assessment by His Honour Justice Mahiri, and that it is and you in effect change your mind and say, well, the Court of Appeal have said, well, we're not going to disturb the cost below, so they can go ahead. There's been a 50% award made, and in those circumstances, it's no longer necessary or reasonable to put this matter to detailed assessment. There is absolutely nothing in my submission to stop you from saying, well, that was then, this is now, this is the appropriate way to proceed, and to make the order for the 223 as against the order for the 111. Okay, moving on with this case, and bearing in mind, moving on with this authority, and bearing in mind that there's a slightly different wording, reasonable versus 50%. At paragraph 9, it's perhaps important. What is useful about this case is it was also costs in relation to the preliminary issues, and I confirm while we're here that the costs we're claiming are solely in relation to the preliminary issues. There was an earlier claim for put in April 2024, close to 800,000, but in relation to the preliminary issues it only came to 550, 50% of that being the 223 and 25% being the 111. So it is that issue is already sorted out. And what is interesting perhaps about this case is the approach here. There was a total profit claim here of £27,000. That needs to be borne in mind that there had been an earlier payment of £200,000 in relation to costs. So this was really the wash-up. And the approach taken by the judge in this case was to say, well, I'm not going to order £20,000, but I will order £17,500 as being an appropriate margin. So it's not necessary that it'd be, we're going to see in a moment, an irreducible minimum, but an appropriate margin. And there is of course, you have mentioned that there's a long way to go in relation to this case. And if it should later be found that there has been an overpayment of costs, well, the claimant has a reasonable expectation that there will be more money paid to him, and that's recognised by the Court of Appeal. And so there was always a provision for the repayment of those costs from future sums. So it doesn't need to be an irreducible minimum, and nor with respect, in my respectful submission, the order that we've got dated August 26th is an order for the payment of the 50%. It's not an order for payment onto account, and it wouldn't be appropriate to then say, well, yeah, that's an order for payment of 50%, but I'm ordering that payment paid into court because of the difficulties that will cause the claimant in relation to the pursuit of his litigation. Now,
sorry, Mr. Bowden, just to interject quickly.
Please.
On that point, with the 27th of August order, which was the order of His Excellency Justice Nour Hineidi, are you saying that your interpretation of the cost order in there is that it's not subject to a detailed assessment? Because in my view, that's not the case at all. I had a look through the order, and I think the language is very clear. When you assess costs on the standard basis, typically costs are assessed at anywhere between 50% to about 70% of the costs claimed. Right. And that's just a benchmark. And when costs are assessed on the indemnity basis, it's typically between 70% and 100% of the costs claimed. Yes. And I think, if anything, based on the order of Justice Nour Hineidi, he's saying that, you know, costs will be assessed on the standard basis, and in fact they'll be assessed on the lower spectrum of the standard basis, yes, being the 50%, but they're still subject to a detailed assessment if the amount is not agreed. So I just wanted to know your thoughts on that before you walked me through the rest of your submissions. Thank you.
I did not understand from, I mean, I accept almost all of what you say, in terms of the order that he made. I did not understand from the order that he had gone on to make the detailed assessment, or the order for detailed assessment. In fact, he left that in your discretion, and that then the order for detailed assessment came in effect from yourself, Madam Registrar. And what I wish to draw at is the tension between what must, in my view, have been an immediate assessment of 50%, and then the further order for detailed assessment. And if what Justice Nour Hineidi ordered was an immediate assessment, can we then have a detailed assessment after that? And I think the answer, in my respectful submission in relation to Rule 3828, is no. They're in the alternative. Now, if it's the other way round, as you said, that he made a standard assessment of just the percentage, and that may or may not go on to detailed assessment, well, we're at the 25%. So if what I submit is correct, that he made an order for immediate assessment, my submission is it should be 50%, and if the proposition which you just put up for consideration is correct, the order should be 25%, half of that payable immediately. And I accept that if you understand my logic.
I understand your reasoning, but the general rule is that or the default position is that where a costs order stipulates that costs are to be assessed by the registrar if not agreed, that typically will always mean that costs are to be subject to a detailed assessment if not agreed.
Okay.
Otherwise, there would be an immediate assessment of costs, you know, on the judgment. I'm not sure that I can even make an immediate assessment following such an order like this. Usually anything that's referred to the registrar is always subject of a detailed assessment. Otherwise it would go before the trial judge or the judge who's had conduct of the file, because they are in the best position to make an immediate assessment of costs.
Okay.
So one thing you could do, and one thing that, you know, to clarify the position is to seek clarity from the judge in which the order could be amended under the slip rule. Now, I'm pretty certain he meant a detailed assessment, but if he did mean an immediate assessment for any reason, then obviously I'd need to know the authority that I have to make such an order, because I don't think I would have the power to make an immediate assessment, even if I wanted to, on the basis that I didn't make the substantive order, being the 27th of August order. Now, going on the submissions that you've just made about the 25% payable, that I think is the best case scenario, because what we would do is we would halve the costs in the event that I do make an order that costs be paid on account. We would halve the amount that's been claimed by your client, and then from the half, I would have to make a very quick assessment as to how much I think definitely will be awarded to your client. I'd have to look at the statement of costs, and I'd have to hear submissions from the other side. I have to take into account things like how much the other side has incurred in costs in order to benchmark the amount that would be awarded for the interim payment to your client directly. So I think at this stage, we have to proceed on the basis that the 27th of August order is subject to a detailed assessment. Like I said, immediately after this hearing, the parties are free to clarify the paragraph with the judge, and then, you know, we can kind of go from there. But for the moment, let's assume that it's a detailed assessment, please.
That's fine, and you might have seen that I had, whilst I hoped for more, I had somewhat anticipated that would be the situation, and that is why I've made that, added that further row to my table above paragraph 11 there with the 111,000 in anticipation that would in fact be the result. That's fine. I think what I would say about that is that, well, number one, the defendant has had since April to have a stab at what it believes is the appropriate level of interim costs to be paid, or costs at all, and it's declined to do so. And I suggest respectfully that it has declined to do so because it knows that if it ever nominated a figure, it would be required to pay it forthwith, and so it's declined to do so. So it is, I think, bound by its own actions there, the defendant is. And that's my submission in relation to that. The other thing is the order for the 50% as set out in PD 5/2014, and that's the key difference between the DIFC rule and the English rule, is that the DIFC rule in fact makes your job easier by providing a ready reckoning. And so the legislation or the rule anticipates or directs that 50% will be reasonable unless there's good reasons to consider otherwise. So it takes away the need for any sort of preliminary assessment of a detailed assessment. If it already, and in this case, you have the added level of assurance that we're only actually looking at 25% of the entire amount sought. And so there is, in fact, a considerable margin, very considerable margin built in, which needs to be taken into account there. If I could just move on to the next case in Hull and East Yorkshire, because there are a few points in there which are germane to what we've just discussed. And so if that's suitable to you, it's also bookmarked down there.
Thanks, Rhiannon.
We're on how it's bookmarked number 5, I think. And the first paragraph, which is actually useful, sorry, not bookmarked, is paragraph 4. Just looking there at the order which was made in that case, very similar to this, as was actually, I didn't mention it, but basically the same order was made in Ashman. So they're making similar orders as I set out in PD 5/2014. The defendant shall pay the claimant's reasonable cost to date to be subject to detailed assessment in default of agreement, and such cost to be paid within 28 days. And so moving on from that order made by the judge, this case then came to consider an application for immediate payment based upon that. And then if we just move on in relation to paragraph 6, no, sorry, made a mistake in my notes there. We'll move to paragraph 21, and that's bookmarked there. And just the last paragraph, the last sentence, 2 sentences of paragraph 21 in Hull, it seems to me that even if assessment is not ordered immediately, the courts can still order a payment on account of costs. In other words, an order for detailed assessment is not a prerequisite of making an order for payment on account of costs. And so all I'm saying is, even at this late stage, you retain the discretion to make whichever orders you see fit. Moving on to paragraph 28, and this I think is important. At 28, as I understand those passages, Morland J recognised that solicitors engaged in heavy and protracted litigation, and I think this litigation easily qualifies for that, are entitled to expect an adequate cash flow. It is clear from paragraph 11 of his judgment that voluntary interim payments are anticipated. However, in default of agreement, Morland J anticipated the judge could exercise his powers, and that is to make these interim payments. And so there is, in my respectful submission, an expectation that where you have sort of distinct stanzas in the case, or distinct applications in the case which have been dealt with, that costs will follow the event and interim costs will be paid. I mean, that's the whole purpose of the interim cost regime, is to provide the essential lifeblood. And indeed, it's got to be said in relation to the costs that we're looking at. They're not for his current solicitors, they're all in relation to his past solicitors. And so his current solicitors unfortunately won't get anything, but such is life. Now, if I could just move to paragraph, I think, 40.
Just please bear with me. Thank you.
And there, and this is a point I adverted to earlier. The second answer is that the primary remedy of the defendant who has overpaid costs to the claimant's solicitors is to deduct such overpayment from the claimant's damages. That is unattractive. It might not suit Mr. Khalifa, but that will be the result. And so therefore, I again swing back towards the 50% as being the default position, and indeed interim costs are said to be the default position. That's set out in the letter dated the 28th of October, which is also in this bundle. And so interim costs are a default position, and when it comes to the payment of interim costs, the 50% is the default position, and there's an expectation and really an entitlement to the payment of costs to keep the litigation going, and it's very stark here. Mr. Khalifa's solicitors can cut him some slack on their fees, but they're not in a position to meet fees on his behalf, and that's got to be the position going forward. So for him to have access to justice, he does need these fees. And then the last matter is the other decision. It was attachment 2, the Court of Appeal decision of November, sorry, English Court of Appeal decision of November 2020, Lord Justice Phillips, in the case of Muhammad Zaki Musavi. Have you got that before you? It was attachment 2.
I do, thank you.
Right. And just very briefly in relation to that, I cut out most of it. I hope you'll forgive me, but it simply wasn't relevant. And if we move, I've bookmarked hopefully paragraphs. Well, if we go to paragraph 72, and this is probably the locus classicus judgment on costs as Excalibur Ventures versus Texas Keystone. And there, Clark LJ rejected the proposition that the test to award the sum was an irreducible minimum. And this perhaps comes back to the comments that you made earlier, Ma'am, and that is, the extent to which you need to inquire above or below the 50%. So it's not an irreducible minimum. Any amount that turns out to be an overpayment, which in my respectful submission at 25% has got to be unlikely. There's a manner of resolving any problems that arise, and so you can have quite a bit of confidence going forward that 25% is the amount. And there, again, the distinction between these cases and the matter before you is what is the reasonable amount, and frankly the DIFC method seems to be a much better one, more to commend it, because it saves you from having to undertake that distinction. However, what is perhaps useful here is that if we move down to paragraph 74, and there it is, this is perhaps what you were talking about before, Madam Registrar, and that is a logical approach is to start by estimating the amount of cost likely to be recovered on a detailed assessment, and then to discount this figure by an appropriate amount margin to allow for the error in estimation. So that's the English approach, and I'm saying that the best approach here is probably 25%. And I think it's useful here that what was asked for, and we're paragraph 76 now, sorry, what was asked for there was £633,000, and the judge ordered just on 50% of it, being 325 after that rough and ready assessment, having already said that it was an eye-watering sum. So even in relation to, in that case, even in relation to something that the judge called eye-watering, the judge didn't have any difficulty ordering just on 50%. And in relation to this case before you, well, we started at 550, so 111 has that margin very much and comfortably built in. Unless there's anything else, I would simply just return to the earlier parts of our agenda and simply confirm that we want to pay the listed fees there. I'd simply ask for a decision by you in relation to the letter for the Chief Justice of 300. If it went to the Chief Justice, well, it's payable. If it didn't, in fact go, we might look to be let off that, but we're not going to quibble over these matters. And so the detailed assessment, the only issue there in relation to the detailed assessment of if we're only going to be proceeding at this stage on 50%, I've in fact cut the amount of the detailed assessment in half, so that it's based on 223,000 dirhams, whereas the earlier figure suggested of 7,666 repeating was based on the original claim of 550. So I'm suggesting now, in a slightly modified form, that the proper amount for the fee for the detailed assessment is 7.5% of the 223,000. And apart from that, we simply have the appeal costs, 5,000, the CMC, as you're aware, we filed CMC applications. As you're also aware, you've directed that we should file them again, which we're happy to do. And we will, in fact, I think, await the outcome of our application under RDC 44.145 before proceeding with that. But we will be in a position to proceed promptly. The letter for the Chief Justice and, of course, the payment for today. Unless there's anything else, and we'll happily, they can be deducted from the payments to us, or Mr. Cowra will, of course, draft up a further undertaking. Unless there's anything else, those are my submissions. Thank you.
Thank you very much, Mr. Bowden. I've got no further questions. Mr. Chadwick, over to you. Thank you.
Great, thank you very much. I have a few submissions. I will be referring during the course of to the memorandum that the claimants have provided, which from the basis of the submission just made, Mr. Bowden, I believe you have a copy of. And I will also be wanting to refer to the breakdown of costs that were provided in respect of the Court of First Instance preliminary issues hearing. There isn't an e-bundle being lodged with the court, but I'm able to point to where it's been filed in the court forms if we need to take you to that. It's in relation to it's inside a skeleton argument that was filed by the claimant on the 27th of April. And I'll take you to that when I get there. Okay, starting point is just maybe an obvious point, just to make sure that we are talking about the same thing, because there sometimes seems to be a bit of confusion, possibly from the fact the word interim is used in both matters. There is a distinction to be made between an interim payment on account, which is what I believe we're looking at now, which is under the RDC 3813, which says where the court has ordered a party to pay costs, it may order an amount to be paid on account before the costs are assessed. Interestingly, the actual order doesn't use the word interim, but people call it as an interim payment on account. And that's to be distinguished from, just to make sure we don't get confused, an interim cost certificate, which is under 40.36. And that arises where you have commenced a detailed assessment, and there's an application for an interim payment to be ordered in relation to the detailed cost assessment. But we clearly are not talking about that matter, because 40.36 says the court may at any time after the receiving party has filed a request for a detailed assessment hearing issue an interim cost certificate. So this one can't arise until a detailed assessment request has been filed, and that hasn't happened in this case. It's always open to the claimant, once they commence a detailed cost assessment, to request an interim cost certificate, but that's for them to perhaps do another time, and we will respond to it if it's made. So we are looking at a payment on account in this matter, not a cost certificate. Now the payment account, as has already been drawn to your attention, is pursuant to 3813, and also in the DIFC, it's also affected by Practice Direction number 5 of 2014, which says that where the court has ordered a party to pay costs subject to detailed assessment, unless agreed, it will order 50% of the amount claimed in the statement of costs paid on account before the cost is assessed, unless the court sees fit to order otherwise. We submit that the effect of those words, unless the court sees fit to order otherwise, means that it is not automatic that 50% will be ordered, that the court has to take a view based on what available evidence is before it, on what amount it should be ordered as a payment account, and it may be less than 50%, depending on what the court takes a view on that. It's interesting to look at the English equivalent rule, which was drawn to your attention earlier. That has slightly different wording. It's in CPR 42.2 subbracket 8. So it says where the court orders a party to pay costs subject to the assessment, it will order that party to pay a reasonable sum on account of costs, unless there is a good reason not to do so. So their phrase is unless there's good reason not to do so, well, our phrase is unless the court sees fit otherwise. But I suspect that the test that's going to be applied by the court is basically the same. What I think I will accept is that based on either under the English rules or the rules here, we have DFC, it's the burden on the party who's paying to establish that there is a good reason not to do so, or the court should make an order other than 50%. So I accept the burden of that is on us to persuade you on. Okay. Now the recent Court of Appeal judgment that came out yesterday has now clarified matters helpfully. It's made the position much clearer, because it's clear now that in respect of the Court of Appeal proceedings themselves, each party's got to bear its own costs, but that the Court of First Instance order in respect of costs, which was made by His Excellency Justice Omar El-Mahari on the 27th of April, remains in place, to use the phrase used in the order. So it's untouched. We still have that, or that's the order we need to look at. And that order that the defendant pay 50% of the claimant's costs related to trial of the preliminary issues, and, quote, such costs are to be assessed by the registrar if not agreed. And that is taken from the actual wording of the order. In the conclusion of the judgment, paragraph 26, it also deals with this point. In considering the success of the claimant in the determination of preliminary issues and the conduct of all the parties, I consider that the appropriate order would be to award the claimant 50% of his costs of the trial of the preliminary issues to be assessed on a standard basis, such costs to be assessed by the registrar if not agreed. I would submit that this wording is very clear. There is no room for it to be interpreted that it's an order for immediate assessment of 50%. The court was ordering an assessment, and that has to be a detailed assessment, because if it's not an immediate assessment, the other option is a detailed assessment. I think it's immediate assessment, and it's made clear it's going to be done on a standard basis. So my friend's suggestion that this order somehow is a order for an immediate assessment of 50%, I think is just simply wrong. You have indicated to him that he is welcome to seek clarification from the judge, and if he does so, we'll see what the judge says, but I respectfully submit that it's clear it's a detailed assessment has been ordered. So the email we received from the registry yesterday was very helpful in clarifying that the only issue we're dealing with is still with this question of entitlement to apply for on account or in court of 50% of the cost in the absence of an application for detailed cost assessment. I think that question can be broken down into three parts. The first one is, can the claimant apply for an interim payment of costs without first commencing a detailed cost assessment? Second point is, if yes, should the court order 50% payment of costs or some other percentage appropriate? And third one is, should any interim payment of costs be paid direct to the claimants, or should it be paid into court? I tend to sort of go through those 3 points now. In respect to the first question, can they make an application without first commencing a detailed assessment of costs? I have to admit that I have not been able to find any cases that completely clarify this point. So I'm forced to just argue basic principles, in which I'm saying that I would submit that this is a payment on account. So there requires to be eventually a detailed assessment. I would submit that unless we know for certain that there's going to be a detailed assessment, we're left in a strange position if we make a payment account and no detailed assessment is ever commenced. What happens? We've had to make a payment, but we don't have a detailed assessment, and it's for the claimant to make the detailed assessment. It leaves us in a very unenviable position. So I submit that it's logical that there must be a application to do a detailed assessment before there can be a payment account.
Sorry, Mr. Chadwick, to interject. Something that springs to mind is the fact that there is a limitation of time period for the commencement of a detailed assessment. And in the event that an order is made to pay 50% or less, as in 50% of the amount of the 200 odd thousand dirham amount directly to the claimant or otherwise to be paid into court, then this would mean that the defendant is paying a pretty small sum in the grand scheme of things. So even if the claimant was to not file an application for a detailed assessment, I would suggest that the amount that might be ordered by reason of the 50%, for example, would be an amount probably that your client would have agreed to anyway. So that's something to think about. But obviously, there are also provisions in the IDC which provide for the defendant or the person who, in who the costs order was made against, they have opportunity to apply to the court, essentially ordering or directing that the claimant now files its application for a detailed cost assessment. So I have had a look at that. It's not something that would be pending or hanging over your client's head until forever. There is a limitation of time constraints, and there is also the factor that your client can make the application seeking a direction from the court that the claimant now files its application for a detailed assessment. So something to think about.
Yes, I agree. If they fail to make the application after a certain time, the paying party can apply to try and force them to make the assessment. So yes, I accept that we would probably be able to force an assessment if necessary on the matter. And that's all I propose to make submissions on that point. I'd like to turn instead to now look at this situation of should the court order a 50% interim payment, because as the paying party, we have an entitlement to have the bills carefully scrutinised at some point, but we also have a view that we shouldn't be ordered to pay money into court or money into the defendant which won't ever be recovered. And we're worried about this because the claimant has clearly indicated that he's without funds, and any overpayment I think will be very, very difficult, if not impossible, to be recovered. I know that it's argued that we can seek to have that deducted from any damages awarded, but at the moment it's completely unclear whether there will be any damages that will be recovered. That's an issue for the trial court at the end of the day, and we don't know whether there will be any damages. So I don't think that provides us any security at all. That's the point I'll go back to when I get onto the subject about payment to court. What you will need to do in assessing whether or not 50% should be the right amount is take a look at what evidence we have got available to us and see whether or not what they're asking for is has flaws in it, and which we will have good reason to seek to challenge. What I'd like to take you to is the actual cost assessment that they provided. This can be found in their skeleton argument, which is filed on the 27th of April 2020. Are you able to access that?
Just bear with me, please.
Thank you.
Thank you. Okay, Mr. Chadwick, I've got that in front of me. What paragraph?
Well, first of all, there's the claimant's cost submissions, and there was also annexures to those cost submissions. It's the annexures that I would like to take you.
Okay, the 41-page annexure. Got it.
Yeah, that's right. So if you go into that, the first annexure is the breakdown of the costs as they were originally being claimed in the run-up to the preliminary issues trial, and the amount they were claiming then was much higher than now, because they were also claiming fees that were paid to Stevens and Harwood and Bin Shabib, which are the first two items there, and those are no longer being claimed, as they have they have accepted that their costs that should be only those costs which are incurred in respect of the preliminary issues hearing, and I assume that the Stevens and Harwood and the Bin Shabib costs were not relating to that. So if perhaps you can also open up in the case memorandum, the memorandum that was submitted by the claimants yesterday, at paragraph 10, you see what the cost is that they're now claiming, and you'll see that Hamdan El Shamsi's firm will claim 470, which is the same as in that original schedule, and 50,000 was also for the firm, and those are the two items they're still claiming.
Mr. Chadwick, that was. Could you just refer me again to that document?
In the claimant's memorandum they filed, they have a little table saying what they're claiming now, just comparing it with what they were claiming back in the annexure 1 of the
current memorandum. Got it. Thank you.
Okay, so you see the two tables are similar, except they don't have Stevens and Harwood any claim for Stevens Harwood fees or any claim for BSA's fees. Those have dropped away.
Right.
Okay. Just on this table, I just mentioned that they're claiming they're now claiming Hamdan El Shamsi's fees are 470,000, the firm's fee 50,000, but there is a figure also of 36,000, which is in brackets 813. This relates to costs that were awarded to the defendants on an earlier matter, which was a figure that was agreed, so there's no dispute over it, and the claimants have quite reasonably agreed that amount should be set off from any payment into court or payment to defendants that should be made, which is why it's a deduction. Anyway, before if you go back to the annexure document and scroll down to annexure 2.1, we can see the another table which sets out a breakdown of what Hamdan El Shamsi's law firm have incurred.
Yes, thank you.
They have the 470 figure compared in the total in the first little table. There is an unless application which they're not claiming anymore, which is why they're only claiming 470. But what I would like to draw your attention to is the hourly rates being claimed by Hamdan in this table. Roger Bowden is being claimed at an hourly rate of 3,000, and Noran, I'm not sure how to pronounce the surname, El Mefleki, is being charged at 2,000. We would submit those rates are excessive. The Registrar's Direction number 1 of 2017, which sets out indicative hourly legal charges, which I believe is the last one that was issued on this point, sets out what sort of rates are normally permitted by the DFC court. Noran, it doesn't say this here, but I've seen from another case a cost statement was at that time a 3-year qualified lawyer, and for a 3-year qualified lawyer, the rates that are normally allowed were 1,762. So this is 2,000 is considerably higher. And for Roger Bowden, he's not a partner, I don't believe at the time. So he would fall under the category of lawyers who are qualified 10 years or plus more. And the normal rates for that such a person is 2,448. So even based on these tables, they look like for Mr. Bowden, he's claiming some 25% more higher rate than he should be able, we would expect to be able to him to be awarded when we get to a detailed assessment. We will be making these points at the detailed assessment, but in terms of helping you assist you in deciding what amount should be paid as a payment in court now, I'd like to draw that to your attention. Okay. Secondly, if you again scroll down a bit further, you'll have the detailed breakdowns for Hamdan El Shamsi's firm. But at annexure 3, you get to the breakdown in respect of the firm is 50,000 dirhams.
Just bear with me, please, Mr. Chadwick.
Sure.
Where is the reference to the 50,000?
It's on page 7 of the annexure document.
Right. So was this firm acting for Mr. Khalifa before Stevenson Harwood? Right.
Okay, and just below that on page 8, you'll see their actual invoice. And interestingly, they were actually claiming fees of 100 plus VAT of 169,302 dirhams. And there's a reference in there to advanced legal fees received of 50,000. So from this, I assume that the claimant has not paid the firm for its outstanding legal fees of the 169, and the only monies that the claimant has actually received or paid is the 50,000 advanced legal costs, which because that's the only thing they're claiming at this time. So that must be the only monies they've paid. But of course, if they're receiving monies for 50,000, there's no indication whatsoever what that 50,000 was spent on, or how it was spent, or what work was done, or anything. We just know there's just no information at all.
I guess this is something that can be visited at the detailed cost assessment, but I do understand the point that you're trying to make, in that there's no specificity in relation to how these costs have been accrued. But out of curiosity, how much has Hadif and Partners, or in the event that Swift was had retained other solicitors before Hadif and Partners, what is the amount that's been claimed by your client for the same standard of work?
I can probably take you to the cost statement that we lodged in respect of the interim, the preliminary issues argument. Bear with me 1 second, let me see if I can just find it. I did see it earlier today when I was going through these. Yeah.
There was a statement of costs filed on the 3rd of May 2020. Is that the one?
That's probably it. I'm looking at an earlier one, which is not the right one. Bear with me 1 sec. 3rd of May. I seem to have lost them. 3rd of May 2020. I can't seem to find it on my list, but is that the one where it says claimants costs in respect to the preliminary issues? That's what our estimate was. If you've got that figure, you can. I don't know. I can't. I'm afraid I can't on the case list. I've got case details list I've got at the moment.
It's difficult to see because the only information on the document is statement of costs, and there were 2 statement of costs filed on the 3rd of May. One to the effect of 173 odd thousand dirham, and the other to the effect of 44, I think, thousand odd dirham. But it doesn't specify whether this was filed in respect of the preliminary issues or not.
I'm afraid at the moment I'm not sure. I would need to go speak to them. I can send you an email afterwards clarifying what the amount was that we claimed as costs.
That would be helpful, thank you.
Okay. So our submission is that given the lack of any breakdown, I would make one more point. Mr. Bowden's made the point that we have not made any offer to them in respect of costs. We've been waiting for a detailed breakdown of what the cost claiming in when they were going to make their request for detailed assessment, and then we would have commented on it, and hopefully we'll be able to go back with a figure we're going to offer them at that time. But we haven't yet received a detailed bill of costs. The only thing we've got is those documents that I've taken you to, and we don't really think we have at this time enough information there to go back with a figure. When we do, we probably will be making an offer because it makes sense to try and settle that.
Well, that would be certainly the right approach before I was to make an order. What I would suggest in terms of next steps are that perhaps the parties can have a chat and see if they can settle this. Otherwise, I'd like to see Hadafin Partners' statement of costs for the preliminary issues, and I'd also like to see a fresh document filed by the claimant setting out the costs that he would be claiming in the detailed assessment. So it won't be a document that will be essentially filed for the detailed assessment. It can be a document that sets out the skeleton of what will be suggested at the detailed assessment. So some kind of submission which is a little bit more detailed than the small table that's been provided at the memorandum, at the back of the memorandum that was submitted by the claimant. So that document really would marry up the costs that have been provided in the statement of costs under the skeleton argument that Mr. Chadwick has just walked me through now, as well as the costs that have been claimed by Mr. Khalifa in the current memorandum, and they provide a little bit more detail on how those costs were accrued and why certain costs have dropped off, etc. So that would be very, very helpful, and I think what the claimant ought to also do is to factor in the hourly rates set out in the registrar's direction for how much members of the profession can claim as hourly rates for their costs. I do think that the hourly rates set out in the skeleton that was submitted back in April, they are quite exaggerated. They are quite high. I don't have a question mark as to whether these were charged or not. Obviously, I know that the law firm does have integrity and it wouldn't be fabricating hourly rates, but I do think that they are very, very high. And the rates that are set out in the registrar's direction are quite generous, and they are based on market rates, even though the direction is a couple of years old. So unless you've got any further submissions, I do think that the parties ought to take the next few days having a discussion about whether costs can be made, whether they can reach a settlement in respect of costs. If they can't reach a settlement in respect of costs, then I should expect to receive the claimant and defendant submissions on how much each of their clients have accrued on costs of the preliminary issues. And then I am likely to make an order that costs be paid on account. It would be a conservative figure, but I'm likely to make an order because I am convinced at this stage that there is no need for the claimant to file an application for a detailed cost assessment before costs can be awarded to him on account. I also don't think that costs ought to be paid into court because I think that would then halt proceedings essentially, and given that Mr. Khalifa is or has indicated that he is financially strapped, he shouldn't be held or kept away from his costs. But I will again emphasize that the amount that I am likely to award will be a very, very conservative amount, because I also agree with Mr. Chadwick's position in that currently the substantive issue is really neither here nor there. We don't really know which way the court will rule on the substantive issue and whether Mr. Khalifa will receive damages in his substantive claim against Swift.
Madam Registrar, I did have a few points in reply, which actually I mean, it's very helpful what you've just said. Do you wish to hear me very briefly in reply?
Yes, please go ahead, Mr. Bowden.
No, sorry, can I interrupt? I haven't yet finished my submissions. I have a couple more points.
Of course. Sorry, Mr. Chadwick. Why don't you proceed and then we can hear Mr. Bowden.
Almost finished. I hear what you say, and we would invite, if we cannot reach agreement on our costs, that the amount percentage that should be ordered should be a lower percentage than 50%. I would also like to just take you back to the table that is produced in the claimant's memorandum, where they have set out their table, which comes to a total of 111,000, where they've done 50% or 50%. In our view, this table has a slight flaw. I'd just like to draw to your attention. What they've done is to take in the HRS's fees and the firm's fees, then deducted 50% of that, and again the 260. They then set off against that figure of 260 the 36,813, leaving a total of 223, and then taking 50% of that. What we say they should have done is take HAS's figure plus the firm's figure, deducted 50%, yet then taken 50% off that figure, which would get you to 130,000, and then set off the 35,000 that is payable to us, because otherwise we're having 50% of these costs that we're entitled to being set off, being produced. If you do it that way round, the total amount, instead of coming to 111,824, comes to 93,418.
I agree, Mr. Chadwick. I was going to actually point that out because mathematically, even though I'm certainly not the sharpest tool in the shed when it comes to maths, but it should have been done the other way round, which is making, as you've said, halving the amount and then reducing the 36,000 and then using a proportion of that amount to be paid on account. So I do agree with that. Thank you.
Thank you. And my last point I wish to raise is concerning about this payment in the court point. If the Court of Appeal decision that we just received had been the last word, I would be inclined to agree with you. But it's not. What we've got is, now that it's been drawn to our attention, because we didn't know until yesterday, we see that the claimant has made an application to reopen the Court of Appeal decision. Now, we don't know where that's going to go or what the final decision is, but potentially it could be reopening the whole Court of Appeal decision. Not only would that might disturb the position concerning costs of the Court of Appeal and may even disturb the position concerning costs of the Court of First Instance, but we, the defendants, may end up having to incur further costs resisting that or responding to that application if we're invited to do so by the court. Of why we think it should be opposed. So that's one application that they have already made, seeking to reopen. And we also have the fact that in the fees that they wish to pay, there's a costs appeal, and that relates to their proposed application seeking permission to appeal against the order of Mr. Justice Omar Al-Mahari, which was issued in August. In which they're seeking to challenge the 50%. In these circumstances, where everything's back still uncertain, we would respectfully submit that it is more appropriate that the money be paid into court until these two applications are finally determined, and we know whether or not the original orders are going to be disturbed, or whether there's going to be further costs incurred in respect to both matters, which would be entitled to set off. And given that the claimants don't have any money, we won't get our money back if we overpay. It's just not going to happen. So I respectfully submit that, based on the fact that things are so uncertain, particularly in respect to these two potential applications back to the Court of Appeal, we would say it is appropriate for the monies to be paid into court. And unless you have any further questions, that does finish my submissions.
Thank you, Mr. Chadwick. Before Mr. Bowden responds to the submissions that you've raised, I wanted to just quickly mention that it is a balancing exercise at this stage of making sure that the claimant has access to justice and at the same time ensuring that no amount is being overpaid to him by reason of a interim order or order that costs be paid on account. So the issue with payment into court is that the claimant will not have access to the funds to then continue proceedings, to pay off his solicitors and, you know, to kind of live his life and put food on the table. That is my concern, which is why I'm at this stage swaying towards making an order that costs be paid on account, but again, making sure that the amount awarded is a conservative sum so that the defendant is not then seeking recovery of costs in the event that things do not go in the claimant's favour. Mr. Bowden?
Yes, thank you. I will reorder the table accordingly as discussed. I must say I had been intending to make the point that we'd been generous to the defendant because we gave them 100% while only seeking 50% ourselves on account. And it might have been reasonable to say, well, we'll give them 50% on account now and 50% at the end. But regardless, I will undertake to change the table and which will reduce the figure slightly. Just in relation to the points Mr. Chadwick raises, the first point is the correct rule is in fact PD 5/2014, and whether it's a derivative, or obviously it draws its authority from the interim payment rule in RDC 38. However, it is a freestanding rule of practice, which and it's very clear in saying that when the court orders detailed assessment, it will order a 50% payment unless there's good reasons otherwise. So there's not really too many questions about that in my respectful submission. The rule itself is clear, and that the proper reading and the straightforward reading of that rule is simply to say that it will, when the order is made, the order for the payment of the 50% will be made, meaning that of course it's going to precede the filing of the application, and for very good reasons here. Otherwise he hasn't got the money to pay it. And of course, you're well aware, I'm sure, of the commentary in the district court practice, DIFC court's practice, that the interim payments are the default rule. And that's also set out in attachment 1. There's also our letter of the 18th of October 2020, which goes into the default position, etc. there. Now, the other thing, coming back to the order of His Excellency Justice Al-Mahari, it is the rule, he said, assessed by the registrar if not agreed. Now, I'm pleased to hear from Mr. Chadwick that he wishes to agree to costs, but it does fall into the category of news, and so there's been no attempt to agree so far. I respectfully say that time is up, and we're really talking now about 111,000 dirhams, and we don't, with the greatest possible respect, wish to get into a detailed assessment about the detailed assessment. So whilst I'll of course do what the registrar has directed, I do caution that we need to take a broad brush approach. When it comes to any overpayment, well, we are talking 25%, and one does, again, have to have a straightforward approach to this and say, well, what is the chances of 25% ever being excessive? And these were not costs on account. These were costs payable. So these costs, they will stay, the entitlement to these costs will stay with the defendant for the rest of the case. And so he has effectively won this round, and this is the entitlement, the lifeblood that he is entitled to, and that's really that. So what the example would be this: if there was, say, an order for 25% to be paid, 50% of the 50%, and the detailed assessment extraordinarily came out and said that actually it was 20% of the 50 of the sorry. If there's an order for the payment of 25% now, and at the detailed assessment, the proper figure turns out to be 20%, it would be that 5% which is recoverable, nothing else. And I'm assuming there's no confusion about that. Not the whole 25% being recoverable. The next point I wish to make is that all this comment about rates, well, yes, fine, but I do refer the registrar to paragraph 10 of Ashman, and there, if we actually might be helpful to just have a look at it, if that's in appendix 1, attachment number 1, sorry, at tab 4, and then we're at paragraph 10 of that. It's not a big decision, and there, paragraph 10. The question of excessive rates is another matter. I also bear in mind that all the work seems to have been carried out by A-grade fee earners, for there being no delegation. And then, so those are exactly the points that my learned friend Mr. Chadwick makes. However, the solicitor's total profit cost the claim to £27,000. The significant hours is recorded as being spent. It should have been possible to delegate. I think, again, a point that Mr. Chadwick wishes to make. The paying party should not be asked to pay more than is reasonable and proportionate. But then the judge nevertheless went on and ordered £17,500 out of £27,000. So he's making an order there in somewhere in the order of 60%, 65%. So notwithstanding that the same sort of matters were raised, the judge there had no qualms in saying, well, yeah, okay, fine, I accept all of that, but we're still looking at 65%. And the question must be that Mr. Chadwick says that I should have been charged out at $2,400 an hour, and I was charged out at, I think, $3,000. So there's a 30% overpayment there. About 25% overpayment there. If that's true, well, it'll never come back below 50%. Now, there's no 50% overclaim that my learned friend has pointed to. The few hundred dirhams, he says, in relation to Miss El-Maklafi. And then coming to the reason for that, yes, Mr. Al-Shamsi most certainly did bill all of those figures. And those were the agreed rates with the claimant, and they were higher because Mr. Al-Shamsi not unreasonably assumed that he might be in this very situation here, that he may be waiting a while for his money, and he certainly has been, and I understand he's been very, very patient. However, he has an entitlement to be paid, and as I've previously said, this money, it's not coming to the current solicitors. It all goes either to the claimant in repayment of sums he's paid, and in relation to the pressing matters that his previous solicitors, in good faith, have given him, if you like, not given, have provided an anticipation of getting paid, and they wish to be paid. And he has been under, I have to say, significant pressure from previous law firms, including, it's got to be said, Stevenson Harwood, who started this claim and went right back to the beginning. Dealing next with the firm, the amount of 50k is the amount that the claimant paid to the firm. There was an amount of 169,000 claimed by the firm. Mr. Khalifa does not regard that as being a proper fee, and has some question marks around it. So therefore, we reduced the amount claimable on behalf of the firm and put brackets interim around it because Mr. Khalifa had some concerns about the justifiability of that bill. And that is a matter that we've invited them to come back on and we're intending to put forward at the detailed assessment. So this, you know, we have tried to be fair. We haven't thrown the kitchen sink at it. And where Mr. Khalifa felt that there had been an overcharge by his lawyers, he is not intending to go and get the money that they don't deserve. The only next points is, that's it. Thank you very much. I have nothing further.
Thank you very much, Mr. Bowden. The only comment I wish to make is in respect of the practice direction. I think that while the operative, or you say that the operative word is will order 50%, the discretionary factor is then, or comes into play by reason of the second part of the paragraph, which is unless the court sees fit to order otherwise. So that would be what the court would essentially rely on in the event that less than 50% of the amount set out in the statement of costs is awarded.
Yes, yes. But if I could just answer that, you would have to be in a position where you could say, as a a matter of on the balance of probabilities, that it is going to go below the 50%, i.e. that this has been gross overcharging. And even those matters which my learned friend mentions would never fit. They don't soak up the 50%. That's my point.
Good. All right. Well, thank you very much for your submissions. We'll let the parties discuss and see if they can come to an agreement. If the parties can't come to an agreement, then could I please ask that statements of costs are uploaded by December 9 at the very latest, and the court will issue an order shortly thereafter. I don't propose that there be any cost to today's hearing, so in actual fact I'll reserve the cost of today's hearing and we can deal with them at the detailed cost assessment as well.
Thank you.
Ancillary. Thank you very much.
As the court pleases.
Thank you. Thank you, Mr. Chadwick.
Thank you.
Thank you very much.